Welcome to our podcast for Kalra Legal Group. My name's Anita Kalra, the Managing Director and Senior Solicitor. Today we're going to talk about disciplinaries without the drama. There can be a lot of drama involved, so let's get into it. What do we see is the best process when it comes to disciplinaries and making sure that employers follow the right process?
I think first of all, as we've mentioned in our previous podcast, is that your handbook is the Bible. So as an employer or employee, please refer to your disciplinary handbook and the policy within it to ensure that you start taking the right steps in order to conduct a fair disciplinary process.
Yeah, 100%. If you don't have a handbook, make sure you get one in place.
Yeah, exactly.
I think as well, you look at the ACAS Code of Practice. You can call ACAS and get some general advice, but the ACAS Code of Practice really spells out sort of the key things for disciplinary. It'll be tailored to your business depending on the size of your business. For example, who chairs the meeting? Often managers don't want to chair the meeting. They're scared to be put in that position of having to make a difficult decision, especially if they're friends with that person, and it can become a really sticky situation.
Yes, making sure there's no conflict of interest.
Yeah, exactly. Or there's even in smaller businesses, we've heard stories about employees that are cousins or siblings or in relationships with each other, and of course you can't have any decisions being made by people that would not be impartial.
Yeah.
ACAS Code of Practice is definitely a good starting point.
Yeah.
For sure.
So if a business owner is like a family-run business, or actually the startup founders were all friends to start with, this is quite common.
Yeah.
Definitely in that situation, they can reach out to HR consultants outside of the company, external providers to come in and carry out the process.
Yeah, and I mean, no one enjoys a disciplinary meeting. Can't say the word now, but I've done it. I think Ravni, you've done one.
Yeah.
Nita, you've done one as well, and I think it's we've done more than one, but you know what I mean. But it's not enjoyable, but it's just about making sure you're doing it in the right way, in a consistent way.
And just as a disclaimer, that's not for us, that's for clients.
Yeah. For us.
But in terms of the process, generally you would start off with an investigatory meeting.
Yeah.
So that's where potentially allegations have come to you of misconduct or gross misconduct. And sometimes in the handbook there are examples of what this could be. But this could be something in relation to IT. It could be absolutely anything, bribery, lots of situations that can occur in terms of disciplinary. Yeah, any misconduct, yeah. So the process would be investigatory meeting. And then if the allegations stack up or there's enough evidence, it would then go to a disciplinary meeting. So, Callum, I'm going to leave this to you. Mm-hmm. Tell us what the process would be when it comes to a disciplinary meeting.
I think our favourite word for disciplinary meetings is just to prepare. Prepare. I know it's a cliche, but ultimately you need to make sure that you have all your questions ready to ask. All of your evidence in place, because ultimately that investigation stage is so important. I mean, I'll speak about one example that we had a few years ago now, and the client called us up. There's been a fight in the workplace, not effectively saying this person needs to go, but we know what happened. We said, all right, slow down a minute. Let's collect the evidence, follow the process.
Yeah.
And then when we saw the CCTV footage, we saw that actually the person that we thought was the instigator wasn't the instigator.
Yeah.
And the whole picture changed literally off of the investigation process. And it was actually someone else who ended up getting a disciplinary sanction.
Yeah.
So I think the investigation stage is so important, and as part of that preparation, you prepare from the very beginning. You prepare for the investigation as well as the disciplinary.
Yeah.
Speaking to the right witnesses, people that were there, if they feel comfortable to do so. And doing it quickly as well. If you don't do it quickly, then memories begin to fade, or people start feeding each other false information. You start seeing, we've seen it in the past as well, statements that look identical from two different people, and you think, right, that's just copied and pasted. Maybe ChatGPT.
Yeah.
But preparing in the disciplinary stage is really important.
In terms of a sort of responding back to the employee, when do you think an employer should go back with a result or outcome for the meeting?
I mean, it depends on the nature of the disciplinary. I think some of the more serious things, for example, theft.
Yeah.
I keep talking about fighting in the workplace, stuff like that. They're really
because
serious
we see
stuff.
those quite often where it's theft, arguments.
Because that's the stuff that people call you about straight away. The
Yeah.
more serious stuff, that's when ultimately we get called, right, this has happened, help us fix it.
Yeah.
And then it's literally trying to turn it around as quickly as possible.
Yeah.
Or
Or what should we do in this situation?
Yeah, 100%.
Or the police have
Guide
been
us through the
called.
process.
Yeah.
Or yeah, there's a police investigation. Can you help guide us through both the police side of things as well as the employment side of things? But sometimes it could be a decision's given, the same day or the next day if it's very serious. But sometimes an employer or the decision maker, I should say, might need time to have a think about it. They might need, say, 5-6 days just to really relook over the evidence, relook over the statements. Because once you speak to that person that's been accused, you start thinking, well, actually, maybe I do believe them or maybe I don't believe them. And we say that to people that deal with the meetings all the time, that just really, really take care in what that person's saying and take it on board and take time to make a decision before you decide. Don't rush into it.
Yeah, so I think definitely dealing with the process calmly, because sometimes when there's allegations of misconduct, gross misconduct, we can sometimes go into that process without the calm approach. So it's making sure you deal with it really calmly. At what stage would an employee be suspended?
I think, again, quite serious circumstances such as, an allegation for gross misconduct.
Yeah. Sexual harassment.
Yeah, exactly. It could even be theft. I know we're mentioning it again, but really serious circumstances. That's mostly when an employee would be placed on suspension. Yeah. And again, dealing with the situation quite calmly and effectively, ensuring that the employee is also, their well-being is also okay. I think that's still quite important as well, because effectively, they're suspended, they're not working. Yeah. So, and
the allegations may be unfounded.
Absolutely.
So they could be fabricated from somebody else in the organisation.
They could even be sort of life-changing allegations. We mentioned sexual harassment.
Yeah.
Someone could be accused of sexual harassment, and it could be a case of, if it's not upheld or it's not founded, it's false allegations, that person could lose sort of their family as well as their job. So it's massive implications.
Yeah, 100%.
On a person.
And suspension normally, is that paid or unpaid?
Usually paid. Employers are reluctant, I think, sometimes to pay someone when they're pretty confident that they've committed the allegation. But ultimately, sort of like you see in TV programs, they're not guilty until it's proven. So that's where the preparation, the investigation process comes into it.
Yeah, it's usually paid, but of course it depends on the policy you have in place as well.
Yeah.
So after the investigation meeting has been held and there's enough grounds or evidence to go to a disciplinary hearing, you would normally then send the employee an invite, giving them sufficient time to prepare for that meeting and ensuring that they offered the right to bring in a colleague or trade union representative. That's really important. We see that missing from these invite letters very often, but that is their right to bring in an employee or trade union representative into the meeting and making sure that you outline clearly what the allegations are. It's no good bringing an employee to a disciplinary meeting and then extra allegations are added on the day of the meeting, because unfortunately you've not given the employee sufficient time to prepare. And we see this quite often, and where actually found where the employer then realizes there are other things that have happened, and that's fine, but it's just making sure you've given the employee notice that actually another piece of evidence has been found, and actually we want to question you on this further to see whether or not those allegations are founded.
And if that letter's not prepared properly, that in itself could mean that the whole process is unfair.
Yeah.
Which I know it sounds crazy, but literally the whole... Even if you know that person's committed... I know, let's talk about theft again. That person's committed theft.
Yeah.
You've got all the evidence there, but if you haven't invited that companion... or you haven't given them enough time to prepare... the whole process is unfair, and they could have a claim for unfair dismissal, which of course the compensation, it wouldn't be the same as if, the entire thing was unfair. And that the decision wasn't right, but ultimately it still opens the door up for a claim, which could have been avoided by getting the letter drafted. And we obviously help employers with templates for that.
And we'll draft the whole letter and to ensure that everything is covered. But actually recently I had a situation where a client came to me and we were acting on behalf in this situation of the employee rather than the employer, and she wasn't actually even sent a letter, which really surprised me. She wasn't sent a disciplinary letter, and she was asked to attend the meeting the next day, so she wasn't aware of the allegations and she wasn't given the right to bring in a colleague or a trade union representative. And surprisingly, the chair of this meeting was actually legal counsel. And legal counsel in this situation thought it was sufficient for the employee just to refer to the handbook. So actually, we don't agree with that approach. You should always make sure there's a formal invite sent out. And actually, it's making sure that an appropriate person also chairs the meeting, because depending on the situation, if it's allegations of sexual harassment, you might want legal counsel, but otherwise that's a fairly heavy-handed approach. It's making sure that there's an appropriate chair that can make a decision as well.
Yeah.
If need be.
And you mentioned things from the employee's perspective, and sometimes it's very easy for an employer to forget that the employee is still a human being at the end of the day.
Yeah.
And they're really stressed by the situation. They're not sleeping at night. They're calling up a friend. How many calls do we get a year from a friend of a friend of a friend who's been accused of a dismissal? And they've got a meeting tomorrow and they need support at the last minute.
Yeah.
And it's just doing things in the right way to support them.
Yeah. And I think a definite no from us is making sure you go through a process. You don't just go ahead with dismissal.
Yeah.
So we see this all the time where an employer will approach us after they've dismissed the employee, followed no process. And that is completely the wrong thing to do. It's making sure you follow a fair process throughout the whole time.
Yeah, and we guide employers through the process from top to bottom. We've had people call us and say, it's usually on a Friday afternoon, this has happened in the workplace. We need a suspension letter. We need an investigation invite, or we need a disciplinary invite, and then we just draft it and sort of talk through the situation with them, just to make sure that they're very clear in their head of what they need to do.
Yeah.
As a client.
Yeah.
And then they can follow that through and pass that on to their managers.
Yeah.
That's a really important point, because it means that they have someone to go to as well after they've gone through the disciplinary process. They have somebody impartial or a solicitor they're dealing with, and they can talk through with them the decision they wish to reach and the rationale behind that. So after a disciplinary meeting, generally the time frame is about 6 days. Of course, if it's something to do with the police and you've informed the police of the allegations, it might take longer. That can sometimes be a longer approach, but if the police are involved, but otherwise it should be 6 days where an outcome is delivered in writing. And really good outcomes also have a rationale behind it, so the employee understands how did the employer get to that outcome.
It almost sort of puts them back in place where they're thinking, stops them in their place where they think, well, actually, I'm not going to take further action. I'm not going to bother appealing it. I'm not going to bother taking it to a tribunal, because it's all here in black and white in terms of the rationale.
Yeah, and they understand it's reasonable then in terms of the approach being taken by the employer.
Obviously, you're going to get your employees who think that they're right and the employer's wrong. Employers out to get them, and sometimes employers are out to get them. But I've seen some of the letters that you've drafted, Ravneet, where you've literally just broken it down so clearly, and it's sort of like you can't really argue with this.
No, for sure.
And we get sent letters like that too all the time.
Yeah. And do you know what? It's a really topical subject, because actually only yesterday I saw an outcome for a case that went to tribunal, and the employer used ChatGPT for the rationale. So what they did was they went ahead and chaired the meeting and put in the deliberation and how the meeting went and the minutes into ChatGPT. ChatGPT then gave them a rationale and an outcome. And this is most probably one of the first cases that's gone to tribunal. And unfortunately, in that situation, the employer wasn't able to justify how the outcome was reached. So what they said in the tribunal hearing was they relied on ChatGPT to guide them.
That's crazy.
And no doubt it was an unfair dismissal case. It was founded that it was unfair and that the process was unfair. So it's making sure you understand the outcome being given to the employee. So I know a lot of AI platforms are being relied upon at the moment, but if you don't understand the decision, then if you are invited to tribunal, you won't be able to explain your approach.
And it's interesting you mentioned that, because I dealt with a matter where it was a redundancy situation, so it was still a type of dismissal. And in terms of the appeal wasn't upheld, and some of the wording was unusual. So our client put the response into ChatGPT.
Okay.
And or put all the information to ChatGPT and said, come up with a finding. And half of their times they did it, it came back and it said, yes, it should be upheld. And the other half said it shouldn't be upheld.
Oh, wow.
And it was one of those things where you sort of see, and you can sort of see it from the language and the way they're writing, that it's not normal language either for that person, or it's too much legalese in the writing, and it didn't really make sense. So you could kind of sniff out that it was ChatGPT.
Yeah.
But it was really interesting to see.
Yeah, I feel like ChatGPT will give you the answers that you want ultimately.
Yeah, you can set it up that way, right?
Yeah,
you can set it up and
exactly.
say, this is the outcome I want to reach. I sound like someone who's used ChatGPT.
Yeah.
But this is
You
the
use it
outcome
frequently.
I want to reach. Help
Yeah.
me come up with a rationale for it.
No,
Yeah.
for sure.
But you just got to be so careful, because, of course, in this situation, the chair of that meeting was actually the employer, and he didn't understand why he wasn't able to give a justification to the tribunal when being questioned, why he went ahead with the dismissal, because he relied so heavily on ChatGPT. So I think, again, that's a really important point, is just making sure you understand what the rationale is and making sure that the decision is reasonable.
Yeah.
Once you've reached the outcome and you've delivered the outcome to the employee, what's the next stage?
So the next stage is...
So if that employee appeals the outcome within the appeal period, which is normally 5 working days, what would you do next?
So from an employee's perspective, again, going back to what Callum said earlier, is to prepare. Prepare your submissions, prepare what you're going to say in your appeal meeting. I think that's so important. And, if the decision is ultimately not in your favour and, effectively, let's say you have been dismissed, we always advise our clients to attend the appeal meetings where we completely understand that it causes that animosity and kind of a sour feeling for an employee, but it's so important for them to attend this appeal meeting, to prepare their submissions and put forward ultimately their case. Because let's say the employee has a case for unfair dismissal on their hands, this is something that the tribunal would look at, is whether, the employee exhausted internal procedures, and those internal procedures effectively is an appeal meeting. Again, being calm, collective, and again, while we completely understand that it's a very worrying and serious situation as well, but to conduct themselves in a way that they're clearly putting forward their points and their submissions. I think that's so
What about from an employer's perspective? So if an employer receives an appeal and the appeal brings maybe new evidence, how should an employer deal with it at that stage?
I mean, it depends on how the employees put forward the appeal. If they've drafted a good appeal and they sort of, like you said, put this evidence in place, probably should be considered really in terms of a fair process, because ultimately it might change the whole outcome. And sometimes you see it where employees haven't been able to access the information for whatever reason. Maybe it's time constraints. Now they've got it and it needs to be considered. But I mean, an interesting point that I always struggle with, to be honest, to advise employers on, is whether they should let that person take the meeting from a video conferencing software like Microsoft Teams or Google Meets, or whether they should do it in person. And I always suggest try and do it in person. But I mean, how many times do we speak to employees that don't feel comfortable going back into that office?
Into that environment.
It's tough. It's really tough.
I think if you can create a safe environment where you can conduct it via Teams, I think there's no issues. But I think most probably depends on the allegations and the severity. So if there's allegations of sexual harassment, it's most probably going to be far better to have the employee in, and you're going through those allegations with them and the appeal process. But the appeal process is so important because there could be fresh light that's brought to you, and it's a fresh pair of eyes looking at the information. So when you get to an appeal process, the chair for that appeal does need to be different. And ultimately, our advice would always be that the chair is more senior to the disciplinary chair. So from a hierarchy perspective, when you're thinking about who should chair the disciplinary meeting, you would want to ensure that if the employee does appeal it, that chair is higher up in the organisation.
You almost have to build it into do have to build it into the plan from the beginning. You have to think, right, if the senior manager is dealing with the disciplinary, then we need like a director level perhaps to deal with the
Yeah, just in case they need to
appeal.
overturn the
Otherwise, they're going to be
the outcome.
the business is spending more resources in sort of
Yeah.
getting it.
But the
other
appeal
people
chair
involved.
otherwise may not feel that they can actually overturn the decision made
Yeah.
by their manager or by the director of the company, which is why it's really important that the person dealing with the
Yeah,
appeals
and I
more
think
senior.
that's where it's helpful for example, for us to step in and make that decision, because ultimately we're doing it in a fully impartial way, and sometimes it's doing it in a way where it's not what the employer would pick, but it's doing it in a way that protects them in the well, not what that manager would want, but it's protecting the business in the long run, which is ultimately what we're here to do and support them with.
Yeah.
Just going back to the employees, at what stage do you think they should, either instruct a solicitor or contact ACAS?
We get asked that a lot, don't we? We get asked that probably once a week, at least.
It's a good question. I think it really depends definitely on the allegations.
Yeah.
I think if you've got severe allegations such as gross misconduct involved, bribery, theft, sexual harassment, I would actually engage with an employment solicitor very early on in the process so that you're advised throughout that process as well. Same for an employer. So if the employer has these allegations on their desk and they need to deal with them through the disciplinary process, should really engage and seek advice from the early stages.
Whenever I get asked, I always say sooner the better. And ultimately, it might be that you only want to have a 20-minute conversation with us to start off with, or a half an hour conversation, and then you think, okay, at least I feel comfortable with what because of course, like we've spoken about today, we know the process inside out, and we can sort of guide them through that process and what to expect.
Yeah.
Because a lot of the time it's a shock for the employee, or the employer is not familiar exactly with what needs to be done or what pitfalls to look out for.
Yeah.
Especially for that specific situation.
Yeah.
It's like sexual harassment we spoke about. Employers can forget it's not only about the person that has been accused of committing sexual harassment.
Yeah.
It's also looking after the potential victim.
Yeah.
Because ultimately, if you don't, then you've got a grievance on your hands.
Yeah.
Because you haven't supported that employee, and that often gets overlooked.
Yeah. And you're right, because that employee
that we've seen
is hoping for an outcome soon as well.
Yeah.
What was the outcome reached during that process?
Yeah.
And they may be feeling really vulnerable during that period of time.
And they're waiting for months and months, and
yeah.
because of course an employer has to do the due diligence to investigate it, but then that employee is left sort of waiting to pick up the pieces depending what the outcome is, and their life's in sort of turmoil. Employees really take it home with them. Employers take it for granted sometimes.
Yeah, and I think if an employer has lack of resources to deal with the process internally, there are resources outside. You can instruct external consultants. A lot of employers approach us and we deliver the outcomes as well and chair those meetings. But it's making sure you do it in a timely fashion, because the ACAS Code of Practice is very strict. So it's making sure you do it within a timely process, but also it then doesn't take too much time away from the business as well. And for those people that might be involved, because there may be quite a lot of witnesses involved that you may have had to speak to during that process as well.
Maybe not dozens, but it could be half a dozen,
10
witnesses that have all seen it, or especially if it's like a historical act or it goes back months and months.
Yeah.
I speak to loads of people, and that, especially over summer holidays.
Yeah.
How many times do we see it when people go on leave during summer holidays and they're inaccessible for 2-3 months properly, and then the investigation or the disciplinary is paused for 2-3 months, and that's not fair on anyone really. And it just creates more problems later on down the line.
Yeah. I think as well, in the unfortunate circumstances where you've got to dismiss an employee and they appeal it, it could very well lead then to that employee raising a complaint with ACAS, which is called early conciliation, and that lasts for up to 6 weeks. So, Ravni, just talk me through the early conciliation process, and for all the listeners out there today that may not know what early conciliation is. What's early conciliation?
So early conciliation, effectively, I'd call it a mediation service where you are assigned, you kind of fill in this form. Either your solicitor can do it, or you can even do it individually, ensuring all the details are correct. And effectively, you're assigned a conciliator, a mediator, let's say. And they kind of go back and forth from the employee or maybe former employee to the employer, and to come to some sort of resolution. Very rarely we do receive kind of comments from employees where they say that they want to return back to the company, but most of the time they are looking for some sort of compensation.
Yeah.
And this could be, I don't know, 6 months of salary plus their notice, or anything that would cover their losses. And this is a service that is available to everyone, and it's a mandatory service that you need to go through to see whether you can actually sort the situation out before it escalates to the tribunal. And we've had quite a few successes in going through the ACAS process. And
for employer and employee.
It works for both.
Where we've successfully negotiated low settlements for employers as well.
I mean, one of the questions we get asked a lot is, when should we contact ACAS? When do you think that they should contact ACAS to sort of kickstart that process?
Personally, I think when you've gone through the appeal and you've come to, they've given you a decision of that you're effectively dismissed, I think that's a good point to contact an ACAS conciliator. They're not there to provide advice. The advice would need to come from either an employment solicitor.
Because it's just a conciliation service, really, isn't it?
It's a mediation service, and I think that's what people do forget as well, that they're not there to provide you with advice, just to kind of mediate the situation. And I think when you're not, when the outcome that you received is not in your favour, I think that's the point where you can contact the conciliator. And I think that's prior to also receiving advice from a solicitor as well. I think that kind of goes hand in hand, because you don't want to kind of pursue a claim or that doesn't have any grounds either. So
it's another thing we get asked a lot is when someone's called ACAS have asked them, what do you want? And then that person goes, oh, I don't know what I want. And then they call us and they say, well, what should I be asking for? And that's when we sort of come in and say, well, actually, based on your claim, this is what your compensation would look like. And
loss of earnings.
This is what your loss of earnings is. Okay, this is what you get in a tribunal, but let's be realistic. You're trying to settle without going to tribunal. How do we get you to that outcome? And then we'll provide them with advice from all of our experience. Plus, obviously, knowing how employers tend to work in terms of they're not going to usually settle for big amounts. Without filing a claim. There's no real incentive for them to do that. It's sort of just doing it.
How does an employer handle the ACAS code of practice? So say, for example, an employer gets a phone call from a conciliator. So that's generally what happens. An employee's filed early conciliation. The employer gets that dreadful phone call from ACAS. And how should an employer handle that process? Because whilst it's mandatory for an employee, it's not necessarily mandatory for an employer to engage in early conciliation. So what would we say is the right way to deal with that process from an employer's perspective?
I mean, I'd always recommend they try and find out what the employee wants as a starting point. Because I think ultimately, unless you know what that person wants, you don't know whether it's worth your time engaging in it. Because there's no, if someone, wants £1 million or something like that, that you're never...
crazy amount. Unrealistic.
It's unrealistic.
And we do get those.
I'll never forget, once I had a meeting with a client and I said to him, well, you're not happy with the offer, what do you want? He goes, £1 million would be great. I think we were in the meeting together. And we both looked at each other like, oh no, this is not
unreasonable expectations.
This is not how the tribunal system works. There's a cap in place. But I think it's just seeing what that person wants. And then from there looking at, okay, well,
and what their claims are.
How far apart are we? What's the situation? Taking it on a case by case basis. That's the beauty of employment law. Every situation is different. No two cases are the same. And looking at how that employer wants to deal with these claims as well. Sometimes they have insurance in place. It's sort of exploring all avenues, and then coming to a fair conclusion and
definitely
move forward with it.
So I think it's definitely the first things you would need to do is to establish what the main claims are and whether or not there's any merit in those claims. So that's a secondary point, is making sure if there is any merit, what the value, the quantum would be for those claims. So in an employment tribunal, that would be the remedy hearing. And then fourthly is if that employee has a role where there's quite a lot of roles out there in the market, then that employee is going to secure an alternative role quite quickly, in which case the loss of earnings for any unfair dismissal claim, for example, would be quite low, could just be two months, where you may just then want to offer a month's salary in loss of earnings, knowing that actually they're only going to get 2 months at tribunal. So they're the main things you'd look at during the early conciliation stage, because from an employer's perspective, let's be real, they don't want to offer a lot of money. And if they've followed process like we've discussed today,
they wouldn't have the problem in the first place.
Yeah, exactly. So it's making sure that you've outlined, if you have followed the process, what that process was and why you achieved that outcome. And if you do want to engage in early conciliation, it's making sure that you engage in it. But of course, if you do make an offer for compensation, it's aligned with what the value of that claim might be, if there are any prospects for that claim itself.
Yeah.
Because of course, from an employee's perspective, they're going to want to get the most they can. And it could be £1 million.
And they're gonna feel hard done by, ultimately, the employee.
Yeah.
They're gonna think, wow, I've just lost my job. I mean, speak to employees that have been made redundant, for example. Yeah, it's different from a dismissal under a disciplinary process, but I've just lost my job. I've got mouths to feed, I've got bills to pay.
Yeah.
All I'm looking for is compensation that will cover me for that period of time.
Yeah.
And I think that's ultimately what they end up looking for. And I think if you have that in the back of your mind as an employer, I mean, the beauty for us is we work for both sides, employees and employers. So we sort of
see the perspective.
See the perspective, can put the other side's hat on and sort of say, right, this is realistic, this is not realistic, and really steer it forward to getting a quick and easy conclusion
resolution
for them.
Yeah. Okay, so that's all from us. I hope you enjoyed our podcast in relation to disciplinary hearings. And if you find yourself in that situation, do not hesitate to reach out to a legal professional such as ourselves to seek any advice. That's all from me. Thank you very much.